Yes.
I beg to mention, my lord, transfer petition criminal matter was last posted on 10/5/2024 and was directed to be listed after 2 weeks, my lord. Matter was not listed. Kindly, matter may be listed on 7, my lord.
7 not possible. 18th.
18th. If possible, my lord, a bit earlier, my lord, 10 or 12, my lord.
Why?
My lord, it's a transfer of matrimonial proceeding, my lord, section under section 125 CRPC, and the matter is stayed here, my lord. And
You are
pending
for
for
the
last,
wife or husband?
I am for wife, my lord.
Okay, 7th.
Obliged, my lord. And my lord, another matter, item number 36, my lord. Learned senior counsel AM Boraj out of station. So, my lord,
Item?
item 36, my lord. Okay. Matter will be listed after 3 weeks, my lord.
3 weeks.
Obliged.
May please your lordship for listing regular bail application lordship.
Motion.
Motion lordship. Lordship, I beg to mention criminal petition number 745/23 for admission lordship. Kindly leave the matter on 14 lordship.
18th.
18 is not possible lordship. Then
Yes, next case.
18, then 20 lordship.
20.
May please your lordship. I beg to mention item number 20, my lord. Pay for adjournment of the matter. My lord, I have also seen CD is also not available, my lord.
CD is there?
Okay. 20.
No. This, give the file.
I have seen, my lord. Notice has been sent, my lord.
Your Honor, I am for the informant. We have received the notice, lordship. So we shall file Wakalat number.
You wait for something.
My lord.
You wait for something. Okay.
My lord.
Adjourn.
My lord.
Inside.
Inside, my
You
lord.
want
Inside. Date may be fixed, my lord.
18th.
18, my lord, because after immediately after
Ask-
the Eid.
ask-
20 or
20.
20.
20.
Obliged.
May I please, your lordship? Lordship, I beg to mention for listing of anticipatory bail, lordship,
Fresh matter.
for tomorrow, lordship. I am obliged.
May please your lordship. I wish to mention item number 9, my lord. Can it be taken on next week, my lord? We have some difficulties.
Okay. On the prayer of the learned council for the
9 and
9 and 10. What about this other councils?
other council is there.
You are for the item 10.
Okay.
You don't have any objection. Okay. On the prayer of learned council for the parties, matter stands adjourned and be listed. Any interim order?
Yes.
What is the subject matter here?
Subject matter, my lord, there is relating to selection of IOI beneficiaries, my lord.
Now, this matters is not for motion.
Yes, lordship.
These two matters has wrongly been listed in the motion column. List this matter in the admission column next week.
All right. Interim may be continued.
Interim order pass earlier shall continue till the next date of listing. Give a date next week. 7th.
All right.
Item
41.
on the prayer of the learned council. This is, you are inside or outside? Then why you seek an adjournment? Anyway, what to do? On the prayer of the learned council for the petitioner, matter stands adjourned and be listed after 3 weeks.
Lordship, I pray for listing of one criminal petition, pending criminal petition. That is, compromise has been done already. So on Friday.
May I please, your lordship?
Yes.
My lord, I beg to mention item number 45, my lord. My lord, as per the last order, I have to file an additional affidavit to bring on record the payment slip, my lord. My lord, I have received the payment slip, my lord. May I pray for an adjournment, my lord, and the matter will be listed on Friday, my lord.
Okay. On the prayer of the learned council for the petitioner, matter stands adjourned. Item 45. Give me the file. What are this office note?
Office of my lord, additional affidavit has to be filed, my lord. I have not filed. Therefore, I am praying for an short adjournment, my lord.
What is the other matter 34? Smita Mathonis. Okay, learned counsel for the petitioner pressed for a day's time to file the additional affidavit. Prayer is allowed. Please this matter on Friday. The case diary be retained.
Hello.
Case diary be retained in the office of the learned public prosecutor.
May I please ask? Well, I beg to mention.
Hmm.
In the item 33, my lord,
Item
33, my lord. Well, since long days, my lord, matter is pending.
Hmm.
At present, my lord, what is the status of trial court, my lord? I am not aware. I could not contact with my client, my lord. It was not the stay order also. So, my lord, some time may be allowed, my lord.
no. Item. Item number?
33, my lord.
Okay. No, not adjournment now. We'll adjourn when the matter reaches.
How
Yes.
Lordship, I have, that day I have, in the motion column, my lord, a matter has been passed, my lord, this POXCO matter, my lord. Only CD has been called, my lord. So it is fixed on 19/6, my lord, but notice has not gone, my lord, till. It is my mistake in my part, my lord.
Which item?
That day, my lord,
Which item?
my lord,
What are your prayer?
that matter may be preponed, my lord. Only CD has been called, my lord. It should go notice also, my lord. This is a POXCO matter, my lord.
Lordship,
There is a, my
Lordship,
Because-
matter was listed for motion,
yes.
and on that day, Lordship, only the
Yeah.
call for notice was not sent to the respondent about to
Yes, not said.
My lord, this is my mistake, my lord. So it is fixed.
When
on
is the matter is fixed?
19/6, my lord.
Let us see on 19/6.
Can it be preponed, my lord, because it will take another
Difficult.
long time.
Difficult. How,
No.
why should we prepone this? File an application, then we can consider, not
Right.
by mention memo.
Right.
You file an application that there is a mistake, notice is to be gone, therefore matter may be, along with the IA, we will pass that out.
My lord.
Yes, next.
Deep level.
For, the bail application, Lordship has called for up-to-date case diary on 13th May,
Hmm.
but date was not fixed. So may I pray for listing a matter on Friday,
The 13th May, date was not fixed.
Friday, Lordship.
13th May is gone.
13 May gone, and the Lordship has not fixed that next day.
Okay,
Yeah,
okay, Friday.
not Friday.
Alright. Just remind me, how, I was telling you, bail, there must be a date, fixed date. Every bail. Yes.
One.
Yes, there. When?
Lordship, can it be on 20, Lordship?
Lordship can be fixed on, this is before Eid, Lordship.
Before,
Eid, Lordship, on 17, Lordship,
let him have the Eid
14, Lordship, on
14th. Try to have it.
Lordship.
There was a recovered. Yes.
Item 2.
For 39 bail application, Lordship.
CD, short date.
11.
So,
43. Supplementary list.
please, your Lordship.
Yes.
Item number 15 is the same.
Item number?
15, Lordship.
15,
Supply.
Lordship, CD is received, Lordship, in 15.
This is what, item number? Huh? It is along with 15. Okay. One. Heard Mr. B.D. Kaur, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor. Listen application under so-and-so. Considered the nature of allegations made, full stop. Also considered the litigational history as regards the dispute of date of birth of the petitioner. And the fact that the petitioner has already been retired from service. This court is of the opinion that subject to the material that may be made available to this court on the next date fix, the petitioner be granted with an interim protection. Accordingly, so and so, so and so, so and so.
Your Lordship will kindly grant me an interim protection
That
because.
is what I have dictated.
Sorry.
Otherwise, why should I dictate all
Yes,
these
yes,
things?
yes. We are.
10 days.
We are. When is the next date fixed, madam?
Give a date after 10 days.
10 days. 18 Lordship. 20.
20. No, 10 days is for his appearance and recording statement. Date you give as per your convenience.
Lordship 20.
20.
Yeah, Lordship.
This is 438 bail application.
This is,
4.
yes, where is the affair?
There is page number 8.
Why should we not dismiss this bail petition right now? Tell us that first. Do you dispute that this is not your wife?
No, you're
No, then we are dismissing this.
You're actually, I have 2 wives. So
2 wives.
so
That is the fact. 2 wives.
Did it-
First wife's house is raided. Then she said he is now living with the second wife. So her house was searched, nothing was found. Then second wife's house, all these arms and ammunitions, and you are seeking for 438. Better be dear, heard. No, will not call for the city. Why should you waste judicial time?
No, I'm an illiterate person. You know.
So what are trying to be literate with these guns?
No.
Huh?
Actually, I'm a labor person. Daily wages labor.
Then where this your wife is a don or what? You are a labor, and all these weapons are recovered from your second wife's house. 1 handmade pistol, 2 numbers of empty cartridges having 8.5 cm4 respectively.
CD we've got
2 numbers of 9 mm live ammunitions. 1 light blue color backpack. There is a height of anticipatory bill.
CD we've got for it.
The CD will call. Is it a right to call for the case diary? What is the parameters that we require to examine under a 438?
Yeah,
If something is not something, admittedly, she is your second wife. Admittedly, that has been recovered from your house on information received from your first wife.
Lordship, this statement makes a very interesting, Lordship. There is a quarrel between the 2 wives. And that's why.
So that's why I'm asking that I think his second wife is a mafia. Isn't it? Okay, looking at his face. Yes, there is.
maybe fix.
Lordship, 24/6.
20.
Average.
5.
Yes.
May it please your lordship. Lordship, the informant took some amount from the petitioner lord in the year 2020.
What is the affair?
FIR is at page number 22, lordship. Vernacular is at page 25. And subsequently, the SEC was issued in the name of the petitioner.
CD interim.
Lordship, may I indicate one thing, lordship? May I indicate one thing? In the FIR, lordship, the case is registered under section 384, 387, 506. But in the format, lordship, in the 154 format, without the leave of the court, without there being any order from the court, police has inserted certain additional sections, lordship. the case was not originally registered under.
Now, then what to do?
No, that's, I'm indicating
No,
lots.
that you indicate when
Lots.
you bail.
Lots.
These cases which are registered are non-bailable?
Yes.
That's correct?
Yes.
Okay, CD intended.
I'm deeply-
24/6.
Use your wisdom
Lots.
and your everything when time is right.
I'm just indicating lots.
No, that indication is no,
Lots.
I'll go and forget everything.
Lots. I'm deeply.
Six.
Yes,
In this case, your lordship, no case has been registered. Despite of that, your lordship, the petitioner,
who is searching you?
police, your lordship.
Where is your statement? And what is the allegation? Filed by whom?
In fact, your lordship, the allegation means one day that petition number 6 was called.
Huh?
One day, the police of the Fakirganj police station called the petition number 6
Okay,
to come, and with that allegation, your lordship, I have made a
no,
statement.
to
in
come
para-
and what? To come and do what?
The paragraph
Come and to, there are 4 kindly see. This
Para?
study, 4.
Report. This is an application under section 438 CRPC filed by the present petitioners with a background fact that police of Fakirganj police station had called them, and therein they could learn that one FIR has been filed by one
Robiul Haq.
Robiul Haq alleging kidnap of the informant's sister aged about 23 years. Full stop. It is the case of the petitioner that the police has not registered any FIR, and petitioner may be arrested and thereafter FIR may be lost. Full stop. In the aforesaid backdrop, the learned Mr. B. Sharma, a learned additional public prosecutor, seeks some time to obtain instruction from the officer in charge of Fakirganj police station, more particularly as regards the allegations leveled in the paragraph 4 of the petition. Full stop.
This station will be Fakirganj, your lordship, not Fakirganj.
Fakirganj.
Okay, Fakirganj, not Fakirganj, Fakirganj. Okay,
Um,
place
Monday-
this matter on
Monday, Lordship.
Monday.
Seven.
Wait, please. Lordship, this is 438 bail application, lordship, FIR on page 14, lordship. I am for accused number 4, 5 and 7, lordship. No allegation against this petitioner, lordship, specific.
Heard Mr. B. Sharma, Chaudhuri, learned counsel for the petitioner. Also heard Mr. B. Sharma, additional public prosecutor. Full stop. Present application is filed seeking so and so, so and so. Peruse the FIR. The allegation involving the rape upon the victim is against one Rafiqul Islam, that is accused number 1. Full stop. And there is no full stop. And considering the nature of allegation against the present petitioner, present petitioner within 10 days.
24, Lordship.
Appear within 10 days. Where is the girl?
Their parents, lordship.
Case diary along with the statement of the victim, if any, recorded under section 164 CRPC.
Item number 8, for motion.
Should I remember this case, my lord?
311
was allowed on the prayer of the PP only for recalling the PW1 to declare her hostile, my lord. Initially,
Suppose she is not declared hostile. This is to your benefit.
my lord, the date specifically stated in the order, my lord,
Ah.
that she will be called only for the purpose of declaring her hostile.
So let her declare hostile. Either way, it is beneficial for you.
My lord, what has happened was, my lord, in this case, initially the informant gave evidence. The informant gave incriminating evidence against me, but the allegations of sexual assault, those were not there. Victim also adduced evidence. Informant was not declared hostile.
Okay, we'll
Victim-
take it up day after tomorrow.
Well, the issue is, my lord, the matter is fixed tomorrow and petition becomes infructuous because it is fixed tomorrow for examination of the informant, my lord.
Okay, we'll take it up after some
My
time.
lord.
Let other matters be over. What is this?
Was fixed for.
Yes, some report was called for.
Yes.
Any report, Mr. Sharma?
After some time.
Okay, after some time. Yes.
Thirtieth benefits to lordship, FRS page 15 lordship.
Page
Page 15 lordship.
15.
Yes, lordship. Witness have been arrested already, lordship. Real estate lordship. My name is there, FIR lordship, Syed Akhtar.
You are?
Syed Akhtar. The list is there, lordship, page 50, 17 lordship.
CD may be called for lordship.
CD. Enjoy in the jail. Yes, next.
That may be fixed, lordship.
18.
May it please your lordship.
In this case, lordship, we are filing objection today, lordship.
They have taken time on 27th.
Okay, let us have that. Let us have that.
On Friday, lordship.
On Friday, lordship, on Tuesday.
Because they are
lordship.
saying.
We are taking it on Thursday.
Okay, lordship.
Today is Tuesday, Thursday. MS DECA,
M.
DECA Learned Council representing the DRI.
Yes, lordship.
DRI submits that an objection opposing the bail petition is being filed during the course of the day. Full stop. In view of such submission, the matter stands adjourned and be listed on Thursday. Full stop.
Deeply obliged.
And 19 also. 19 also, lordship.
All BA.
Yes, lordship. All be. Item number 14, lordship, may it please your lordship. 15.
So out of one FIR,
One,
where is the FIR?
FIR lordship will find on page
Page
16, lordship. And this is for the second time, lordship.
some crores.
It's a lot, lordship.
Hmm?
37 lakhs. 37 lakhs.
Hmm.
That not from this present petitioner, lordship.
Hmm.
And lordship rejection order on page 22, lordship.
Page. I have rejected everybody's application or what?
This
Huh?
This,
Or-
this was rejected, Abdul Hai rejected.
Abdul Hai was rejected,
Where
Lordship.
is the order
That is on page 22, Lordship.
of which petition?
Lordship, item number 15, Lordship, 1315,
1315 page.
page 22, Lordship.
Page 22. Now, who are these petitioner? Tell us.
Petitioner
Name,
Abdul
name,
Hai.
name, name.
Abdul Hai, Lordship.
Abdul Hai. Then
Then in item, Lordship, Baharul Islam Ambani, Lordship.
Baharul Islam.
Ambani, alias Ambani.
He should be not here, somewhere else.
He
The
is,
actual Ambani is not there.
he is the.
Money shows that.
But he has shown arrested, Lordship, in this case, Lordship. For
Now,
item
where
number-
is Ambani's bail?
There is
43, my lord.
Mizanur Rahman. Okay. And Abu Hanifa. And
Abdul-
what is the
No,
other?
Abdul Hai.
Baharul Islam.
Abdul Hai.
So there are two petitioners, Abdul Hai, Mizanur Rahman, and
And this Baharul Islam Alaz Ambani.
Baharul Islam earlier rejected.
No, Lordship. This is shown arrested, Lordship.
What is the Baharul Islam? They are, these two are not getting. Then Baharul Islam.
Baharul Islam, he is the master, he is the main, but he is shown arrest earlier in other cases also there, and shown arrest in the same petition,
What is the stage of investigation?
investigation, yes, these two petition are now 81 days. But Baharul is around shown arrest, from shown arrest is only
34 day, 42 days.
42 days. 40 days. Charge sheet not yet filed, here, fact is that several person, this is organized crime, several person is, because of that, investigation is still going on.
Seek extension. What you will do? You will become wise after period is over.
Because of the, but bail objection-
After the period is 90 days is over, thereafter the in IO will rise up. Oh, I have not been able to come.
objection also given, objection that is on 18.5, but we received the diary on 18.5 subsequent to that, it's not up to date. But involvement, from their statement, yes, we are doing, several persons, someone given money, someone doing business, Mizanure aru moi nokol hona ব্যবসায়ত জড়িত আছিলো।
I have seen that. I have seen the case there.
Nokol Huna, Lordship,
But-
not the fake currency, Lordship. That's what his statement, Lordship.
No.
No, I have seen that. You are initially, you had, let me tell you
Yes.
what the city says. Initially, someone was labor, then used to work in Arunachal, then was involved in the business of fake gold. Then they, from fake gold, they have expanded their business to fake currency.
cow trafficking also.
For 80 days, Lordship.
80 days is not always important because the legislature in its wisdom has given 90 days.
Lordship, in this case, Lordship, recovery is not from this Abdul Hai,
No.
Lordship. In the forwarding report as well as in the Lordship,
Fact is, huge
only-
quantity of money. And Baharul Islam, he is above all, he is doing other
Investigating authority has collected sufficient incriminating material against the present petitioner. Full stop. The material so far collected suggests that the minor was called to Guwahati in pretext of love and promise of job. And thereafter, she was kept in a hotel and the boy left her there with some other girl.
In a lodge.
In a
Lodge,
lodge, full stop. It is also revealed that initially the lodge authority, though refused to allow the victim to stay in the lodge because of his, because for the reason that she was not accompanied by any guardian and she was a minor. However, on the insistence of the petitioner, she was allowed to stay there. Subsequently, she was rescued by her family members. First, considering the matter in entirety, this court is of the view that the custodial interrogation of the petitioner may further be required inasmuch as the material suggests that petitioner had earlier also bought some girls from interior places in promise of job. First, accordingly, the present petition stands dismissed at this stage.
Obliged.
Case there be returned.
Hearing, item 25.
May please your lordship. Actually, the both of the application, we were granted an interim protection, my lord. We have appeared before the IO and given a statement.
Yes, Goswami,
Yes, my lord. They have appeared, my lord.
do you want your what kind of allegation?
No, offense is 304B, my lord. We are the in-laws, my lord. Father-in-law, mother-in-law, aunt and brother-in-law. There's a dispute between the husband and the wife, my lord. The wife.
Okay, you are Shahjahan, Moiram and Raju.
Takmina and Raju. Takmina is number 4, my lord.
Shahjahan, Moriam, Takmina and Raju.
Raju, my lord.
Hard. So. It is an application under interim order. Statements recorded. Now take the dictation. The material so far collected suggests that the accused number 1, the husband
Husband, my lord.
of the deceased
This is-
is the prime accused and prime accused, and there is the material so far collected against the present petitioners, namely so, and the stage of the investigation, in the considered opinion of this court, do not warrant custodial interrogation. Full stop. In as much as the petitioners had cooperated with the investigating authority and there is no allegation that they had tried to influence any witnesses. Full stop. They tried to hamper or tamper with the investigation. Full stop. Accordingly, the present application stands allowed. Interim order passed earlier stands on so and so is made absolute.
I'm deeply obliged.
26.
May please your lordship.
Yes.
FR at phase 8, your lordship. Land dispute, your lordship.
FR is at page
8.
Any interim?
There is no interim.
No interim.
And that is what, man, just preliminary.
Page 8.
Page 8 is the FR. This is type version. Original in English, your lordship. Tell us.
What is your name?
Arezade. Then your
Yes, who has done all this mutation and all?
He is the prime witness, first one.
Secondly, my lord, a preliminary objection, my lord.
No, no, forget about
you-
preliminary objection.
No, my lord, but
Now, who has
Yes.
manipulated this document?
no, my lord,
Is
just-
there any material that he is involved?
he is
That's
very
all.
much involved.
Nothing more is required.
Your lordship may kindly come.
Page 15, your lordship.
Yes,
15.
And just, I want to just point out one thing, my lord.
just come, we'll come to this. Let us,
Yes,
let us hear it. Hear it. Please.
Page 15. This is certified copy of Mohammed, your lordship. At serial number 10, Harez Ali. Page 15.
Page,
15.
page 15. There is no page 15. Yes, Harez Ali.
Harez Ali, serial number 10.
Hmm.
And his name is recorded by the right of inheritance.
Hmm.
The disputed land in question was purchased by his father
Hmm.
in the years 1970, your lordship.
Where is that?
Yes, my lord.
Where is your cell deed?
My lord, I have translated this note, my lord.
No,
Here,
forget about
our-
the notes. Produce the cell deed.
Yes, I have sold it also.
Where is that?
My lord, I have not annexed, my lord. I will.
That is the vital. Because whole allegation is that you have manipulated documents. Yes, that may be a civil dispute. Moment you can show that this is a cell deed, we will give you bail. That may be a civil dispute. We understand, but manipulating record with forgery is not a civil offense.
But whatever done, my lord, by the official, my lord, Lat Mondal.
That's why
circle
you'll
officer,
see,
my lord,
Lat Mondal may,
My lord.
you might have greased the hands of the Lat Mondal.
at page 14, your lordship.
Who knows? You might have greased the hand of many revenue officers.
I have
That
no
will-
idea regarding the. my lord.
That is
So
the exact,
therefore
that
we'll-
is the exact case. my
That is what we'll
lord.
see.
Exact case.
Then there is no question of civil.
And the-
Civil is that I have purchased this, your subsequent sale deed is bad. It was liable to be cancelled. Okay, fine. On the basis of your sale deed, they have done it fine. But the materials are there that there is no sale deed. These are forced document.
The sale deed is for.
We know. Somabandi we know.
By the government official. Lat Mondal.
That is what we want to say, whether these corrections incorporation is made genuinely or by means of forgery. What is that? By means of,
By means of forgery, man.
that's all.
My lord,
Page
sale
14,
deed-
may kindly.
my lord, sale deed that has been.
Let us hear him.
referred-
Page,
Page 14, your lordship. I have translated the note of the circle officer, my lord. As per order dated 10/10/22 of the circle officer passed in mutation case number so and so.
I think
Then-
this Lat Mondal is required to be
Yes, yes.
interrogated along with you.
Yes.
My lord,
That will give everything clear.
if that is true, my lord, then Lat Mondal and circle officer are main
Yes,
person,
both.
my lord.
Both will give the
Circle
direction.
officer
That
has
have, what is the
passed
statement of the Lat Mondal?
My lord, last month, statement is not there, but what I have seen, my lord, the sale deed that has been referred to, my lord, it is not a sale deed, but the report has come from the, my lord, register office, my lord. It was a, my lord, mortgage deed, that serial number, my lord.
Okay, understand.
Everything is false, my lord. And second, one thing, my lord,
Custodial detention may not
Very
be
much-
required. your
See,
lordship.
I
will
tell you the modus operandi. There are some documents, some numbers, which are basically some deeds, long old deeds. Banks mortgage, government deed. Those deeds are, numbers are taken. Then you are given a certified copy.
Yes.
You will never get the original of that deed. If you go to the original, then you will get it's a mortgage deed.
there is the modus in every case.
Now, what about this, who has given him the certified copy? You are still possessing the land on the basis of this? Or you have handed it over? The land to these two old gentlemen and
The
lady?
land under possession since long, your lordship.
Yes,
And
sir.
also,
Goswami,
my-
just give
one-
me the case.
Yes,
brief.
my- again, one thing, my lord, he was granted interim by session court, my lord, at that time. But at that time also, he has not appeared. And now, my lord, they have not come with a clean hands. Now, there is nothing in the, my lord, petition,
Hmm.
whether any, because it is mandatory now, my lord.
Yes.
Whether to, my lord, at least to say whether the bail prayer is pending in
Pending,
that case, or
pending or
whether it was disposed of, nothing, my lord.
My lord, I have filed one additional affidavit. that your-
additionally will not cure that.
My lord, actually, some facts could not be brought.
Okay, give me the case diary.
Lordship, in the additional affidavit, I have stated as to how I could not appear before the IOU. lordship. Actually, he's suffering from jaundice here, lordship. Lordship, may kindly also peruse it. Tell
A or B or C? So this is A, B or C?
I have annexed the certificate also.
What it says?
So may kindly peruse the bail objection. That is what the case, my lordship, in first page, my lord. All the points were discussed, my lord.
Heard. Mr.
Here,
A. Rahman, Learned Counsel for
I
the,
will appear along with all the land documents. lordship.
also heard Mr. M.P. Goswami, Learned Counsel for the petition. Reason application, so and so, so and so. Full stop. Peruse the case diary produced.
बहुत
Though the allegation is made that allegation is made that the land records were fraudulently and land records were manufactured and name of the petitioner was incorporated in the land records pertaining to the land which belongs to the informant. Full stop. The informant, the petitioner, had taken a stand that the dispute is basically a civil dispute, and the petitioner had inherited the land from his father, who in turn purchased the said land by a registered sale list. Full stop. Apparently, it seems that this is a civil dispute over the disputed plot of land claimed and counterclaimed by both the parties. However, the case there reveals it otherwise. The case there reveals that to give the dispute a color of civil dispute, a suit was even filed, a collusive suit was even filed by the accused against the original owner of the land. First stop. The statement of the earlier owner clearly suggests suspect, not discloses, suggests suspect. It is also the material collected by the authority also suggests that the land records were manipulated and petitioner's name was incorporated on the basis of a purported sale deed. Full stop. The material also suggests that, in fact, there was no such sale deed. Rather, the number of the sale deed on the basis of which it was projected that the father of the petitioner purchased the land is a mortgage deed and nowhere connects the petitioner or his deceased father. Full stop. The material also suggests involvement of certain revenue officials in this case. Full stop. Considering this matter in entirety, this court is of the view that custodial interrogation of the petitioner may be necessary in this regard, including the custodial interrogation of the other co-accused, other persons who are involved in this conspiracy. Considering the above, the present bail application stands dismissed. Door is closed for everybody.
It has to
If
be-
PP reminds, if
If-
PP memorizes,
Yes, yes.
My lord, in such case, my lord,
in such case what?
main accused may be circle officer and Mallat Mandal.
Huh? That's why we have
Yeah.
said, there may be interrogation may be necessary for the other accused. Sometimes greasing others' hands creates problem for your own hand.
Hmm.
Yes,
Lord,
case
he
there
is
is
retaining the city,
huh?
retaining the city.
No, no, this detective,
Lord.
case there is return.
No.
Case there is return.
Unless
Yes, what happened to
Date
Bijan?
is, my lord, FIR is page 9, my lord. 9 page, my lord. As per FIR, my lord, is only for hit of my hand
My lord,
and attempt.
Any
that is what
relation?
allegation is.
Any
no,
relevant
not
intention?
relation, he, as per 164, he is harassing and.
No, that we understand because the way lady has described, it's
Yes.
but quite natural.
Yes, yes.
Whatever he says.
But landlady,
Mm.
the house owner, Malat, she stated that they are, though they are using common bathroom, Malat, she Malat makes some toilet dirty, and because of the dirtiness of the Malat bathroom, and the accused several times complained the landlady, and only because of that, Malat, on that day conflict.
Considering the
Maybe
matter in
both the way, Malat.
come on, case there is produced, full stop. The otherwise, this is not a case for custodial interrogation. But don't do all this.
Lord,
You
is
claim
it-
to be a college lecturer. These
He-
people are, it's a psychological disease. These people are called peeping toms. Do you know, this is a medical term. Considered case that is produced. Perusal, the material so far collected by the investigating authority in the considered opinion of this court do not warrant any custodial interrogation of the present petitioner, subject to the condition that petitioner appears before the IO, records his statement, and cooperates with the investigation, and cooperates and do not try to keep contact with the victim, as well as do not repeat such kind of offenses. Accordingly, the present bail application stands allowed with the following condition. Within 10 days appear before them.
Amount, bail amount.
Huh?
Bail amount. Amount rupees.
What amount? 438. You want to go inside and give an amount?
No, my lord. Highly obliged.
28. In this case, my lord, I have the instruction that this petitioner expired yesterday, my lord.
Oh. CD also not received, but.
So, my lord, I may be allowed to withdraw, my lord,
Who died?
the petitioner.
Okay, it is submitted that the petitioner has in the meantime expired. Accordingly, accordingly, the present petition stands closed, being infructuous.
Well,
He died natural death or out of?
possibly he suffered a stroke, my lord.
Okay.
Probably.
Please, your lordship. Also matter, my lord, service in respect of the respondent number 2 is awaited.
These are orders, matter. Wait, hearing.
My lord, he was otherwise available. On the last date, if my lord may remember, we have pointed out that the informant had lost 2 FIRs. And
In the meantime, the petitioner may
yes, my lord,
file
but
an
we could not
additional.
trace out, my lord, any additional FIR, my lord. We tried, but we could not, because since there is no interim also, we could not go to the police station, my lord.
Okay.
Services otherwise awaited, my lord.
Services taken in terms of Deepak Nayak.
Deepak Nayak.
Yes.
Okay. It is submitted that service steps for issuance of notice upon respondent number 2 was taken in terms of notification number. Yes, Asemono. Accordingly, Mr. MP Goswami, learned counsel, learned additional public prosecutor submits that he may be granted 10 days time to obtain the report from the concerned police officer as regards service upon respondent number 2. There is a list after 10 days. Give a date. 24. Bail hearing. Bail hearing over maybe. Orders in a court.
Order, I think, will be 29.
Yes.
Yes, Mr. Ali.
The appeal has already been admitted, my lord,
Hmm.
and I have for suspension of sentence, my lord.
What is the sentence? 10 years.
10 years for appeal number 1,
Hmm.
husband, my lord, and regarding father and mother, my lord, 8 years.
Father and mother, 8 years. Where is the FIR? FIR
They have not annexed.
or anything, any material on the basis of which we can consider
Objection also not being filed, my lord. I will file the objections, my lord.
anything, just take out the what are the evidences important.
PW1, man. PW1 is the father. On the basis of his, my lord, the main crux of the conviction, my lord, that the death was within 7 years. Unnatural death.
How she died? Okay, we'll give them a time to file an objection, no doubt about that.
Died, my lord, by hanging.
She died by hanging. Now, what is
Medical
the material that which compel her to commit suicide?
There is no, my lord, evidence. Father said that after marriage.
Presumption. Is the presumption that she's her 7 years is difficult.
Only death.
If that be so, it's difficult. Mr. Goswami, look into.
Yeah, lordship.
Also, in recent judgment said, my lord.
No, that we know,
Lordship.
but he wants to file an objection.
Yeah.
A short date, and we do not want. Suppose there is no case is made out. Why should people be inside?
Regarding father-in-law and mother-in-law, my lord, there is nothing.
Okay,
Lordship.
That-
1 week, my.
1 week.
Yeah.
Mr. Goswami, learned the counsel for the additional public prosecutor, prays for and is granted a week's time to file objection. List accordingly on
14, my.
14th. On the said date, the interim prayer shall be, the bail application shall be considered. Yes, item?
Please, lordship.
Yes.
Appeal against conviction, lordship, under section 370 IPC. 10 years, lordship, aside.
Appeal is admitted.
Appeal admitted, lordship. And my IA may be considered because.
Any objection filed?
No,
You
here
want
also
to
my
file?
just come up for first time. I will file second.
Oh.
I'll-
Lordship may kindly see in what manner the conviction. is.
LCR received?
LCR not received.
LCR is not there. lordship.
Now, on what basis? Something we need require,
I have annexed all the depositions. lordship.
all the
Yes,
depositions.
lordship may kindly see in
No,
what
no,
manner.
do you think that we should proceed and dictate?
No, lordship.
Then if no, why should we waste time?
The way in manner he was.
See, that way and manner, until and unless we take a decision, what is the meaning for sitting way and manner? I will take a 50 meters. Should I waste time in seeing way and manner in 50 meters where we don't pass an order? If you say that we'll proceed, we'll proceed.
No,
We'll
lordship.
not hesitate.
I have annexed the lordship. may kindly have a look.
Okay, that's fine. But when it is not required, don't make
Yes,
submission.
lordship, shortage may be fixed and LCR may be reminder may be.
Okay, no, because there is a specific order. Why I have asked it that it should be after LCR. This appeal was admitted on 19/4/2024 However, the LCR has not yet been received, full stop, registry to issue reminder in as much as an application for suspension of the sentence is pending, full stop.
In the meantime, Lordship, they may file objection.
In the meantime, they may, state may file objection in the High Court. Yes, next. We know the pressure upon the lawyers, but we cannot just deliver justice, taking note of the pressure on the lawyers. Yes.
24. 24/6, object, oblige. Obviously, yeah.
This is, this relates to me, Zimma of a vehicle.
We'll allow it.
My lord, unnecessary risk. And my lord, there is no progress as per record.
No,
my lord.
nothing is there, and they said that conspicuation is not done. We in fact kept it to allow this petition.
And cognizance taken in February 24,
February.
thereafter no progress, my lord, as per record.
We'll pass this order.
My lord,
Dispose
dispose of.
dispose. Deed us and none appears for the petition. Okay, write the name. Yes, next case.
13 will do. 13, my lord.
Item,
Lordship, 13 Lordship.
what is this?
Lordship, the appeal is against the conviction Lordship of under section Lordship 354, under 2 years. Lordship.
Item 13. First time listed.
First time. Lordship.
Admit. Call for the record.
2 years.
Decision appeal under so and so. এখানে লিখে না, peruse the judgment as well as appeal memo, full stop. Admit, call for the record. Anybody to be noticed to be issued? No.
Sure. Number 2 is there. Informant is-
This is
Yes,
POCTO or what?
54 is there. Initially it was
254 is
No,
required.
Not necessary.
Deepak Nayak, no.
Not necessary.
Full stop. Respondent number 2. Notice to the respondent number 2 is not issued in as much as in view of the determination made in Deepak Nayak versus Swencho, such notice is not required to be issued to the respondent number 2. However, it is needless to say that the respondent number 2 shall have a right to participate in this proceeding if so desires. Full stop. Then what is the period?
Yes, Lordship.
2 years.
2 years. Hard. IA. Decision application under decision application under
After judgment.
seeking suspension and bail liquiber. The connected appeal has already been admitted. Full stop. Peruse the ground as well as peruse the ground, peruse the judgment as well as ground taken in the present application, seeking suspension of the aforesaid order. Considering the matter in entirety, more particularly considering the period of sentence, this court is of the view that there is no likelihood of taking up the matter for final hearing. Accordingly, a final hearing, full stop. The petitioner is also on previous bail granted by the learned trial court below. Considering the matter in entirety, the petitioner is allowed to remain on the previous bail granted by the learned trial court below. Full stop. With the aforesaid, I stands closed.
Pending item number 8.
Yes.
Well, in this case, my lord, what had happened was initially the informant was examined, my lord. Informant implicated me of only assault, my lord, not sexual assault, my lord.
Where is that?
The evidence of the informant, my lord, will find at page 35, my lord.
Just give me a minute.
Immediate citizen কোনো নিদিয়ে যায়।
Accused is also juvenile.
No, this is the second accused, my lord. There are two accused.
Huh.
I am my lord Abu Said. This is another one. There are two victims, my lord, allegedly. I am Abu Said. Shakil is the juvenile.
No, this is the informant.
This is the
They
informant.
want to recall this
They want
informant,
to recall the informant. They initially,
not the victim.
not the victim.
Not
Okay.
So, my lord, what has happened? This informant was examined, my lord, then cross-examined. Prosecution again re-examined this victim, my lord. My lord will find that at page 42. Re-examined, further cross-examined and discharged, my lord. Then victim was examined, my lord. Victim was declared hostile. Then, my lord will kindly come to, this is important, my lord, page 51, my lord. This is the first petition which was filed by the learned special public prosecutor for recalling PW1. Herein, my lord, at page 52, para 6.
Page
52, my lord, para 6.
I am at page 54.
51, my lord.
Page 51.
51 is the first petition, my lord. filed by
Okay.
the learned public prosecutor. Page 52, para 6. They have cited section 22 of the POCSO Act, wherein, my lord, whoever makes a false complaint or provides false information. Page 52, para 6, my lord.
Para 6.
They've quoted section.
Just a minute.
My lord.
Why do you want to recall?
In this petition, my lord, they have said that if she has given a false statement.
Okay,
she is
that
liable-
can be a different
No, my-
proceeding.
Yes, my lord. That petition was allowed by the learned court, my lord, page 54.
Page
54.
Okay.
This was allowed.
Okay.
Then we challenge this, my lord,
Okay.
saying that if witness cannot be called
On for that reason.
for that reason.
Okay, then.
self-determination. That order was set aside by this honorable court, my lord, at page 57, my lord.
Rightly.
Slightly, my lord, set aside, my lord.
Hmm.
Then, my lord, learned, this honorable court,
Hmm.
page 58, para 6, gave an opportunity to the prosecution
Hmm.
that they may file a fresh application giving proper grounds, not this kind of grounds. my lord.
Okay, now what is the proper grounds?
Now they have given, my lord, at page 59, my lord.
59.
59, the ground is a para 5, my lord. Page 60, para 5.
Hard.
My lord. Of the, my lord.
Relevant part-
Allowing the petition. my lord.
Relevant part will be page 66, only one paragraph, my lord.
It is not.
No,
that-
that is
it's
there.
a very reason, he has given some reasons, my learned.
Reasons, what is the reason? That we want to contradiction. Contradiction is already there, you admit it. There are contradiction in 164, 16. We'll need examination of this case, whether under 311 an order can be passed like this. Heard. Mr. Swenso, learned counsel for the petitioner, also heard Swenso. The present petition is filed assailing an order dated
10/5/24.
10/5/24. Page 59.
Page 63, my lord.
These are unnecessary delay. 10/5/2024. Whereby an application filed under section 311 CRPC filed by the prosecution praying to recall PW1 for her re-examination was allowed. Full stop. The PW1 was examined in chief on
My lord, 11/1/2022.
11/1/2022. Full stop. She was cross-examined on
1/2/2022.
1/2/2022. Thereafter, said PW1 was
Re-examined.
re-examined by the prosecution on
1/2/2022.
1/2/2023 and
22.
22 and cross-examined,
Further
cross-examined on such re-examination by the defense on the same date. Same date. Subsequently, an application was filed by the prosecution to recall the aforesaid PW1 primarily on the ground that she had made
First FIR was that she had made, why she had alleged in the FIR commission of rape, but did not.
on the ground that she had alleged commission of rape in the FIR, whereas during deposition she did not support such allegation. Full stop. Such application was allowed by the learned trial court by an order dated
Order dated minus 16/3/24.
16/3/2024. Full stop. On being challenged before this court, the aforesaid order on being challenged by the petitioner, the aforesaid order dated
16/3/24.
16/3/2021 22
24
24 was reversed by this court in
Criminal revision petition 128/24.
1/28 of 2024
Filed
with a liberty to the prosecution to file a fresh petition citing sufficient reason. Full stop. Accordingly, the second application was filed under section 311 CRPC, recalling with a prayer to recall the PW1 full stop. The ground cited this time is that the petitioner, the said PW1 had made contradictory statements in recorded
In FIR statement under 161.
in FIR in statement under 161
And in her evidence.
and in her evidence. Full stop. Therefore, according to the prosecution, she need to be recalled to recall. Full stop. It is true that in order to enable the court to find out the truth and render the just decision, the provision of 311 are enacted. Full stop. However, when it is an admitted position that the prosecution witness has taken different contradictory statements and recalling her will, in the tentative opinion of this court, will be a futile exercise. Full stop. More particularly in a situation when the prosecution has examined her twice and the defense had cross-examined her twice. Full stop. Thereafter, the victim, minor victim, was examined and she had also not supported the case of rape as alleged in the affair. Full stop. In view of the aforesaid, in the considered opinion of this court, this matter needs further examination. Accordingly, issue a notice returnable on July 16th of July 2024. Mr. Goswami accepts notice on behalf of the respondent number 1. Full stop. Steps upon respondent number 2 be taken in terms of notification number so and so. Full stop. Till further consideration, the further proceeding of so and so shall remain suspended.
Deep level.
And you may be made to
We'll dispose it.
because it is in the stage of arguments.
Arguments.
Deep level.
It's a case of acquittal. When your witnesses is not supporting, you cannot forcefully convict some person. That is the difficulty. He may be involved, but prosecution is not, vital witnesses are not supporting their case.
Lordship, here on the last occasion, a report and the CD was also Lordship. I was seeking some time to produce it, Lordship. Any day, Lordship.
When?
Monday, Lordship.
Not Monday, it will be on Monday year after.
18 Lordship. 17 and then 18 Lordship, Tuesday.
Not 18, next month. Next Monday, what is the date?
17.
No. Huh?
No.
17 is a holiday. You take a date that year after next Monday. 24th? 24th. On the Mr. Goswami, Mr. Sharma, B. Sharma, learned additional public prosecutor, submits that he may be, the IO may be granted further 10 days time to produce the case diary and report as sought for by this court under this order dated 20/05/2024. Prayer is allowed. Please this matter on 24th. Huh? Nirupama Soikia to Mate.
Item number 42 to be spoken to.
Yes, madam.
Next, that somebody will be appearing, my lord.
Huh?
Come suddenly.
No, that's not the problem. Problem is that your petition itself is very defective. We are not being able to decide what to be done. In your prayer, vehicle 2, in your petition, vehicle, in your prayer 1, in your 2.
Two vehicle, my lord.
Lordship, may I submit
One is in their custody and one is the papers are blocked, my lord. In the date. There are two vehicles.
No. Kindly see your petition.
Yes, my lord. Which part of?
I am coming to.
Lordship.
Yeah.
Lordship, Mr. P. Bothakur was appearing in this case. Lordship, his mother is seriously ill, Lordship, and admitted in.
No, we have already heard that is not an issue. In fact, we said that we'll allow this petition.
Lordship.
But while dictating the order, we face so much of problem.
Yeah.
এই order to dictate kushali the devo development point. Dictated this. Just a minute, just a minute.
There are two vehicles.
Now, let us understand. Let us come to your prayer.
Page 14.
Mm.
107 here in the parties.
Yes.
Page 14.
Yes.
1-4. Authority to give Zimma of the 120 vehicle bearing registered number so and so and so and so mobile handsets. There are two
Cold
vehicles.
storage chamber number 2. What is this? Okay, unseal is done.
Look at the Khanapa, which is in
Okay,
connection.
this
Again, repeating my.
this is your petition. Okay, fine. Now come to the impugn order.
That is page 55, my lord.
Page
55.
Page 55. Okay, what is this order?
Let us go to the operative part, my lord.
Yes.
Paragraph 3, my lord. Perusal of the case. Record.
Now this relates to only Zimma of AS01 EC 8381.
They forget to write, my lord.
So
They have
who
write-
forgot to write?
Court, my lord.
Where is your application then?
The EC, that is the, my lord.
Where is your
represent
application
the
seeking
track.
Zimma? That is not part of a record.
This one in the mobile phone, WhatsApp, it is there, my lord. We
No,
forget to
Madam,
write.
see, we are sitting here as a judge.
Yes.
Whatever I write,
Whether
this
it
is having a
two-
bearing.
Yes, my lord. Two vehicles are there or not, my lord. I'm seeing the application. Yes, my lord, it is there.
So where
The
is that
application.
petition? Can I record
10
my
minutes.
submission on the basis
10
of?
minutes, no, my lord.
Huh?
If your lordship give me 10 minutes.
No,
I
it's
can
not a
take
question of 10 minutes.
It is there, my lord.
Is it not
the
very
application.
important that you file an
Certified copy
application?
My lord.
Hmm?
Certified copy of the application, your lordship may kindly see, my lord. Kindly you bear with me, my lord.
No, we are bearing with you. We are bearing with you. Otherwise, we would not have, no, I will not look into all this.
At least your lordship can see, my lord, numbers are.
No, we will not see. This is not the way to do a case.
I thought that it will be called, my lord. I could not take out the printer, my lord. Certified copy, that has been sent, my lord.
What is the number of the vehicle?
In the prayer, it is there, my lord.
No,
Both
no,
the
prayer,
vehicles.
which vehicle? Kindly come
Here
to
in
the,
the
what are these vehicle? Tell us.
One is I-20 vehicle, my lord.
And other is?
Other is refrigerator truck.
Other is?
Refrigerator truck.
Refrigerated truck. Now you show us in your petition, where have you stated that I-20 and refrigerated
Yes, my lord.
truck in your
Petition
petition?
the High Court, my lord.
High Court.
Yes.
I can get it at paragraph 3 regarding refrigerated. Please tell me about the that other vehicle. Yes, where is that?
Paragraph might have been left me that while taking out. My lord, how it is dropped, my lord.
No, we do not know. See, madam, a problem is with us. I have
Yes,
spent
my
so much of time in this petition. This is the order dictated, but I could not get anything. You withdraw it, we're closing it.
Actually, my lord, I don't know, maybe in computer, some
No, we do
paragraph is
not
the
know.
left one.
Yeah, you are
The earlier petition, my lord, in the
yes,
order
see,
is
you
also
are a
dictated.
such a seasoned council, experienced council.
But it
We
was
are
because of the
exercising a
police
power
action-
under 482.
Police action, we have. filed
We
it
cannot
early.
give a reason that yes, Madam N. Soikia has forgotten to given this record. However, I take a judicial notice because she has submitted. Can we pass that order? If no, then withdraw this. Would have
So we have filed hurriedly.
with
In
details.
taking printout, my lord, they have made mistake.
Maybe we do
Yes,
not
my
know.
lord, because in earlier petition, that paragraph is there. Earlier petition, when the honorable court has passed the order.
No, forget about other things. You are dealing with a petition where you made a prayer for Jimma. There are certain statements are required. We are not even going to that extent.
Because my lord, earlier
You
petition.
see, madam, see, I should not advise you, but you should better concentrate on these particulars.
Here, my lord.
I tell you what happened.
how
I
it
tell
is
you what
done, my lord.
happened. I
Yes.
tell you.
Yes, my lord.
Not only here, the application you filed before the court, even in that case, the other vehicle's number was not incorporated. Therefore, that order was passed. That other vehicle's number is not there, and other vehicle's number was incorporated either at the on the date of or subsequently by giving an initial signature. You go through it your petition. Heard MS and Saikia, learned counsel for the petitioner. Ms. Saikia submits that there are certain defects in this present application. Accordingly, she submits that.
Allow me to add that number. my lord.
No. Otherwise we are dictating an order dismissing with a liberty to approach this court because there is no particulars. See, we have passed an order, laid down certain parameters. I cannot now change those parameters.
No, my lord. Because of
Okay, we'll
typographical
pass this.
mistake.
Okay, we'll pass this order.
So should I withdraw it, my lord?
Of course.
Okay.
Heard MS and Saikia, learned counsel for the petitioners. She submits that there are defects in typographical defects in the present petition. In as much as the application filed before the learned trial court under section 451 is also not annexed to the petition, and therefore she seeks to file. She wants to withdraw this petition with a liberty to file a fresh petition. Prayer is allowed. List this matter. Prayer is allowed. Accordingly, this petition stands closed on withdrawal with a liberty to file a fresh petition. Full stop. Go through a judgment we have delivered, and there are all the parameters or statements which are required are given. What is that?
Your pardon, my lord. I could not follow the last line, my lord.
There is a judgment we have delivered so far relating to Jimma in terms in case of 2020 Act, 2021 Act. What should be the parameter? What should be the state, and should be the consideration at different stages? And to determine those parameters are things are required to be annexed in.
Number, she will be able to give the number?
Yes, sir.
Okay. One more thing, my lord. I would like to submit that, my lord, we are not covered under that act. Also, my lord, the police is trying to forcefully put that act because
that
it's
is
a parallel
That
act,
is
my
a
lord.
subject matter of the other petition that we have taken note of, that we have given us the time. Huh?
Also because no cattle was found. They, my lord, they on suspicion cattle meat when the forensic laboratory parameters are what are the conditions?
Okay, then we'll pass this order.
No, my lord, that is there. I will close it. I will file a fresh petition because
You take those
number-
grounds, you take those
because
grounds.
of the computer,
See,
they have left
see
some
two aspects
paragraph.
of the matter. Again, I am repeating, this is not my job to advise. But you are seeking a Jimma. Okay. In the case of Jimma, court has decided it to be 20 under Cattle Prevention Act. So therefore, moment courts take it as a Cattle Prevention Act, there will be certain separate thing because the legislature has prescribed certain things in the act itself. Okay. If you say that this is not a case under that act, then we'll have to deliver it in a larger. We cannot give you the Jimma right now. Okay. And in fact, that's why I have said that you better read that judgment. We have said 451 shall also be applicable in case of a cattle when it is beyond the stage of production. So if that be position, your vehicle can be given Jimma. Whether that is a cattle or food, that is to be determined in other case. If you insist on this case, we'll have to deliver it. That's all. Yes,
Discussing
next
the
case.
matter, my lord. And number could be yes, one of-
May I pray, Lord, sir?
Yes.
This item may be passed over. Learned counsel having brief is having fever today. Learned counsel having brief is having fever today.
Fever. Weather is bad.
Later
Case
time-
is like that, I think. That's why fever.
No.
Fever is case. Huh? Seeking what? Questionment?
Crossman.
Okay, learned, it is submitted at Mr. Sinha, learned counsel for the petitioner is indisposed today. Accordingly, a prayer for adjournment is made. Prayer is allowed. List this matter
Next week.
next week.
Please.
Any interim order? No.
Wait, please. My lord, here in this case, my lord, what has happened, my lord? I have come against an order passed in a criminal.
This is hearing or what?
Question, my lord.
Yes.
I have come against an order passed in a criminal complaint case, my lord.
Hmm.
Now I have the instruction that complaint case itself has got dismissed.
Yes, matter it become infectious.
I seek some time so that I can.
On last
The order.
8/2/24, Lordship.
Order is there?
Lordship, in 8/2/24, the Honorable Court directed that whether the appeal is pending or not, appeal is dismissed, Lordship.
No, my lord, there are two things, my lord. Is intermingling things, my lord. This appeal is in respect of a DV case.
This judgment is of what?
Lordship, that what happened, Lordship?
This judgment is challenged where?
In DV case, Lordship.
In present case?
No, Lordship, returning the street done.
Present case is under 406. It is a
Ah.
complaint case. They preferred a DV case at earlier point of time. Their interim prayer regarding returning on the street on was not considered. They preferred an appeal. That is the judgment. Lordship is having. In between, my lord, they preferred a separate case under
Understand.
406.
406.
406, my lord. Now, what has happened? That 406 against the taking of cognizance, I have approached this on the report. Now that 406 to my instruction, that has also got dismissed.
Dismissed for default or something
My
for
lord, that
merit?
is why I have asked to obtain the.
You give the number, we'll get it right now.
My lord.
We'll get it right now.
It is there, my lord.
Nowadays, you need not go to your client.
My lord, order I have seen, my lord, that order is not there. Only it is written dismissed. CR
So if
659.
this dismiss is dismissed.
Let me take the instruction.
Stay by Honorable Court,
Huh?
Lordship. The CR case, whether.
Dismiss for default or for on merit?
No, Lordship, I have also not instruction because.
Hard. Mr. Swenso, learned counsel for the petitioner, and Swenso, learned counsel for the. The present application is filed against an order dated 28/8/2019 passed by the learned Munsif number 3, Judicial Magistrate First Class, Kamrup within bracket Metro at Guwahati in CR case number 6597/2018 under section 406 IPC. Full stop. Both the learned counsel for the petitioner and respondents submits that the aforesaid CR case has already been dismissed. However, they are not aware whether that case was dismissed for non-prosecution or that case was dismissed on merit. Full stop. Be that as it may, as the case has already been dismissed, nothing survives in this petition to be adjudicated. Accordingly, the present petition stands closed. However, it is made it clear that if any fresh cause of action arises, the petitioner shall be at liberty to approach this court once again. Suppose that is dismissed for default, it is restored, he will have a liberty. That's all.
Okay.
Accordingly, the present petition stands closed. Interim order, if any, stands vacated.
My lord.
For this, we should not go to the next date.
Because my lord, the cause of dismissal that I do not know.
That's why we have protected you also, him also.
Yeah, please.
Yes.
Well, the petitioner filed this petition under section 482 CRPC. Well, here is trying to quash the FIR and charge sheet. FIR is phase 12.
FIR is at?
Phase 12. I'm reading the FIR. Respectfully begs to state that the below noted accused person appointed me as a clerk of laborer in the work of railway and paid 1 lakh as labor wage out of 6 lakh and misappropriated 5 lakhs. Moreover, the said person also misappropriated labor wages 7,75,200.
Now then, what happened thereafter?
And thereafter, my lord, the police registered the case under section, my lord, 420 and 406 of IPC.
Now where is the,
And thereafter, my lord, charge sheet was submitted.
where is the search sheet?
Charge sheet, my lord, that is page, my lord, 18.
Mm.
And in charge sheet also, my lord, the investigating agency, my lord, mentioned that there is a case of 420, the page 19. Page 19, my lord, the third paragraph, during investigation, as per the evidence of witness, the case has been well established under section 420, 406 IPC against the accused person of so and so, so and so. Accordingly, the charge sheet has been submitted before the my lord, honorable court. Thereafter, my lord, the learned court below, my lord, on page 22, took the cognizance on charge sheet and issued the summon to the present petitioner for his appearance. And after received the summon, my lord, he filed this case before the honorable court, my lord. Only on that ground, the case is civil nature.
Case is?
Purely civil in nature.
No, there is a prima facie case of misappropriation. There is a statement is made, it is a misappropriation. Meta runs there. Why should it? We'll dismiss this.
Well, the informant will have the opportunity to file civil case also, recover the money.
Oh, there may be file if you misappropriate.
Misappropriate?
Misappropriate because there may be a case that you have the initial reception in mind. You extracted the work and not paid the money. It seems. So we cannot decide at this stage that whether you are guilty or not guilty. Charge sheet is already been filed. At this stage, if there is a suspicion, that's enough. We need some observations in this regard. Or want to withdraw and participate in the trial.
Well, it maybe pass the order, my lord, because already have filed.
Okay,
Not
we'll
his
pass
technique.
this order.
Yes, ma'am.
We'll pass this order, dispose of.
From page 26 to 33, lordship may kindly prove in earlier case. Earlier case, from page 26 to 33, he is praying for time for appearance.
Page, just a minute, page 36 to. I have seen the case diary. We do not know, maybe civil, but at this stage we cannot, after charge sheet, we cannot go to in details. Page, paragraph? 30?
From page 26 to 33 in the petition.
Page 26 to 33.
All the others.
The item may be taken on day after tomorrow. My senior is unavailable today. I'm on behalf of respondent number 2, that is wife of Podesta Tamuli. Your Lordship.
No, we are closing it.
Yes, Your Lordship.
We are closing it.
My senior will argue.
What your senior will argue? Report has come. You have not even filed before the court unnecessarily.
Yes, that's
you have
misleading the court.
unnecessarily brought this. Will pay a heavy cost upon you for bringing this lady, bringing her here. We are giving you a
Your
cost.
Lordship, I have to state only one point. He is one of the taxpayer. But
no, forget about taxpayer. His whole grievance is that I file an application under section 127 that the Clarnet court has not refused to accept that. This is your case. So we call for a report. And the officer has reported, and we have full faith on this officer. One of the upright officer will not disbelieve him.
Yes, my lord.
He has reported that no application is to be filed in the court number 1. Then it is registered, then it is distributed among this court. You are intimated that you file it before 1 and therefore it was not accepted. So you'll have to pay cost.
Lordship, in this case, my senior will argue.
Who is your senior?
F Khan. He is unavailable today due to bad health.
Tomorrow.
The day after tomorrow.
No, tomorrow. Will not, you will have to pay cost, heavy cost.
Yes, my lord.
What, how much fees have you taken?
No.
No, okay. No,
Wife
then-
cannot pay any fees.
Okay. Then we will assure that.
She has daughter also.
We'll assure tomorrow. On the prayer of the learned counsel for the petitioner, matters since adjourn and be listed tomorrow.
Obligation.
We will not tolerate this kind of petitions. Any other matter? Hearing who is, yes, Mr. Mahajan, ready to argue?
I've seen a bit
Interested to argue, ready to argue, 2 questions.
interested to.
Interested to argue. Okay. And madam, you? Interested and ready? Tell us, be frank. Because we'll take some time in this matter. It may spill over to 2 also. Subject to what Nath says. Any matter fixed at 2?
No.
Today you are free.
No,
And what about PP?
Well, we are otherwise ready, but closing ceremony is going on TV, my lord. So we are in anxiety. I do not know what kind of submissions I will make in such.
No, but that will not affect you anyway. Nobody will be affected here. We do not know about Mr. Botha.
I am also will not be affected.
Initially, I was a little bit apprehensive whether we'll get Botha today here. Yes, if somebody is interested, we'll do. Otherwise, we have also too many works in the chamber to complete.
Today itself, some orders have to. be
Yes,
passed
yes,
through.
this is to be done. Because I will pass those order in a chamber because he's awaiting. He's otherwise busy counsel. That's why you are the amicus behind bar. What is the case? Give us quick. Then we'll understand. What is the allegation?
POCSO, Your Lordship, penetration.
What is the statement of the victim?
Statement is forwarded, Your Lordship, 6 years already completed, 7 years punishment. Convicted 7 years, 6 years are completed.
What is the maximum punishment?
7 years.
Minimum. Minimum 7 years. If corroborated, what can we do? We'll appeal this.
Medical examination is not supported the case.
What is her statement?
Ours is-
She is firm.
Says-
If she is firm, forget about medical. That's why I'm asking. So there is no urgency. We'll take it up some other day. Yes, next. Yes. Okay.
Perhaps we may be permitted to leave,
Yes. Yes. Be part of the festival of democracy.
Ceremony. Correct, correct.
Yes.
Lord, I have rearranged the things now.
Okay.
And in fact, Lord, I was reading.
No, we are thinking that today is your first argument. We'll rearrange like this. Okay.
Malad,
We'll
Malad.
dictate this order today
Lord.
and we'll keep the rest for later.
Lordship. Malad, I have after going through the thing, Lord, the position I find, Lord, there are decisions that the sanction is required. Sanction is required, Lord. On the other day, I argued that if there is no failure of justice, then can be.
But I do not think that will be required.
Lordship.
Suppose sanction is required. What next? Okay, you proceed.
Yes.
We'll just note it down.
Lordship. But in the case which I was reading on the other day, the 2023.
That is under PC.
No, just been there. Activities Prevention Act.
Just been there.
Just been there.
Okay, just been there.
Judge.
That was bail.
Judge Bill.
Judge Bill.
In Judge Bill case, discussions are there on sanction also. But if
Which paragraph?
Lordship.
Okay.
If Lordship kindly comes to
You
That
are
was-
relying on Jasbir, then
Jasbir.
Ashraf Khan
And 2011
and Suresh
4,
Kumar become son.
Lordship, on 2005.
One is 2013 3 SCC 77.
Yes, my lord.
One is 2023 SCC online
Yes.
SC 543.
Yes, my lord.
And other is 2012 11 SCC 606
2012 11 SCC 606
and
Lord,
2015 14
SCC 186
SCC 186
and 2005 8 SCC
2005 8 SCC
130.
130.
Yes.
And what is about Ashok Tarseng Bhutia?
Ashok Tarsang Bhutia is already in between, my lord. That is 2011 4 SCC 402. On the other day I relied.
Okay.
That is on the failure of justice. If there is no failure of justice, Lordship will not be interested. That is, my lord, basically I'll my lord praise 2005 8 SCC and 2015 14 SCC along with the others.
Par contra, Mr. Borthakur, Mr. D. Nath, learned senior government advocate, argues the following.
My lord. 2005 8 SCC 130.
First, which judgment you will rely on?
That the Jasbinder Singh I was reading. My lord.
Okay.
I'll continue with that.
To 2020.
2023 online.
Okay.
SCC online.
Okay.
And next is 2014 15 14 SCC 186.
15 14 SCC
186. But their contention of the respondents, I have already taken your lordship to the purpose why 45 was brought in the act. But kindly, but for the dates, but important dates are there. What has happened in that case? That ultimately that is what I'll pray for. Lordship
In this
Jasbir Singh. Yes, my lord. 23.
Is Jasbir or Jasbir? Whatever.
He's
Is Jasbir or Jasbir?
Z-U-D-Z-E. Jasbir, sir. Para 23, kindly, Lordship may kindly come for a moment, my lord. Para 23.
Para
23. Dates are important. That is why I'm indicating, my lord.
Okay. Just a minute. Paragraph 23. Yes.
Mr. Jain, he is for the respondent, my lord. Father submitted that the case was eventually committed to the Court of Session and finally to the special judge constituted for NIA UAPA after taking over investigation by NIA on 22/2/2022, redesignated as NIA court number so and so, and finally the cognizance was
Generally, this is just for my knowledge. Generally, UAPA, the trial court is the committal court.
So it is the session judge court, your lordship, designated as a special court. Your lordship.
Special court is the committal court. Otherwise, in other cases, committal court is different. If it is a session tribal, it will be committed to the sessions court.
It was after your lordship Bikramjit Singh judgment, your lordship, where Supreme Court has held that it will have to be by a special trial will have to be by, and cognizance will also have to be by special court, your lordship. Thereafter this has come.
But in this case, in Jasbir's case, it was sent initially to the committal court, not to the trial court. Okay.
It was on 22/2/2022. It was finally it was placed, and finally the cognizance was also taken by the special court only after examining the prosecution sanctions. The sanction order sanction under the 1908 Act was
Finally,
received on 26/10/2022. Just I'm indicating the difference, 26/10/2022 by the district magistrate Amritsar, which was duly recorded by the special judge NIA on 12/11/2020. The sanction under
just a minute, let us read again. Especially after examining the prosecution sanctions. The sanction under 1908 Act was received on 26/10/2020
by the district magistrate Amritsar.
Now, how can cognizance was taken on when? On?
After. Cognizance was taken after.
Finally, the cognizance was taken by special court only after examination of prosecution sanction. The sanction under 1908 Act was received on so and so. What is the date of cognizance?
Date of cognizance was taken after the sanction. After sanction,
Oh, that is 12/11, I think.
Lordship,
Sanction was on 26/10.
duly recorded and after that sanction was taken,
Okay.
I'll just come.
Okay,
Lord,
okay,
I'll just
okay.
come.
Yes,
Cognizance, kindly come to para 20, my lord.
para 20.
Cognizance of the offense was taken by the special court on 5/4/2021. 5/4/2021.
Okay. Just.
So, my lord, it was placed before the court on
5/4/2021.
2021 at para 20, Lordship will find.
Yes, yes,
See.
yes. Yes, next,
My lord,
proceed.
Lordship, the sanction order under the UAPA by the Punjab government was granted on 6/1/2021. The special court.
Where are you reading?
I'm reading para 23.
Okay.
Next page. Next
Okay,
page.
okay.
The sanction order under UAPA by the Punjab government was granted on 6/1/2021. Special court recorded the same on 7/1/2021. And further, the government of India accorded the sanction under section 45(1) of the UAPA on 17/3/2021. So the next date is 5/4/2021 when the cognizance was taken. Here, one of the issue broadly as regards sanction was that when the charge sheet was filed
Without sanction.
without sanction. So at the time of filing charge sheet, ultimately held that sanction is not required. Sanction will come later. And
No, there is no quarrel on that. Because why? There will be a reason for that. I was thinking.
Yes.
Because the sanctioning authority will have to see the material collected by the investigation. So it cannot be prior to filing of the charge sheet. Because it is completed the investigation, charge sheet is filed. And in this case also they say we have sought for sanction.
Yes. I
So therefore 17 days time, 14 days time is given so that the learned court will wait for 14 days to get the sanction. So to take the cognizance.
That is where my submission is, that I am indicating that it was submitted before the Honorable Court on 22/2/2020. Sanction was received on 17. Sanction was received on 7/1/2021. Nearly after 11 months. And my lord, the cognizance was taken on 17/3 after the sanction. So my lord, that period of 14 days after submission of charge sheet is not correct. My lord, as per rule 3 and 4, it is 7
No,
days.
that you may be correct. She says legislature in its wisdom has not prescribed any time limit for reaching the materials from the investigating officer to the reviewing authority. There is no time frame.
No, there is no time.
No, there is no doubt about it. There is no prescription.
That is my submission.
But this was no quarrel on this.
My lord.
There is no prescription. But what my question was, if it is a stringent act, the legislature in its wisdom has prescribed only 7 days for an expert authority to examine evidence and take a call. And thereafter only 7 days for the government to take a decision, give the sanction.
Lord.
Only 14 days. In that situation, can a reasonable time be read into this period?
Well, that is, I find, is a little bit gray area. I would submit. Here I find.
Why
here
I'm
I find
asking
it
is,
10,
let us
11
have
months.
this debate. Why I'm
Okay,
asking
okay.
is, can we envisage a situation where the investigating authority will sit over this matter for any time to come and whole thing will be initiated only it reaches the reviewing authority? Can that be a proposition or reading of the provision of the act as a whole? Then what will be the reasonableness? This may not be the subject matter of this present litigation.
But it is.
I think that came to my mind.
Yes, sir. Because in preventive detention, the law, as Lordship has indicated, in preventive detention, every day's delay has to be counted from the date of filing of
Counted.
petition.
Say suppose if sanction cannot be taken, then what will happen? A proceeding will await for the lethargy of the investigating authority. Because other parties already legislature has parliament is wisdom and prescribed time. but no time is prescribed for this period. And in fact, after search sheet, no time is required. Send it straight away because you have already collected the material.
There, my lord, before sending for the prosecution, the sanction under 45(2), the authority, while they processing the thing, my lord, they have to be at that stage sometimes.
No, what is the word used so
Uh,
far relating to the investigating authority?
For the
Sending it to the reviewing authority, any rule or anything?
it is not.
It is not there.
It is not there, in fact.
See, why I'm asking is, suppose under section 102 CRPC, when you make a seizure without the permission from the magistrate, the legislature in its wisdom says he will have to produce or intimate forthwith. The word is used is forthwith. In some cases, it has been used the word within a reasonable period of time. Now here nothing is there.
Nothing is there.
Nothing is there.
No.
Neither word reasonable or forthwith, nothing is there. Whereas only 7 days and 7 days times are granted.
After submission, consideration.
So it is only 7 days, but there is no.
That is there. But for the authority, as Lordship has rightly has observed, my lord, that for sending to the authority, recommending authority, there is
Nothing. So can we say, can a court exercising power can presume or interpret that no, it is up to them whenever and whatever?
That will not be good, my lord. That will not be.
Anyway, that may not be a very relevant issue for this case.
For me, it is a very relevant question.
No,
Why?
I will show you.
No, what will happen? What will happen in that
That is
case?
very, now I want to know what will happen.
What will happen in that case? Ultimately, this decision has said that in that case, until and unless the sanction comes or the sanction has come, it is wrong. In that case, he can file a petition for regular bail before the court, not default bail. While deciding this case, this case is basically on 2 points, mainly on the point of default bail. He will not take the default bail.
What I could understand, subject to what you say, here issue was, if we summarize it, whether search sheet without sanction is an incomplete search sheet, and therefore that will entitle a person a default bail. The answer is negated. It says no.
Negative.
Want of sanction will not invalidate the search sheet, and therefore, if search sheet is filed within time, there will be no default bail. This is the issue, I think.
This is the issue. This is the issue. And my lord, on default bail, while deciding this case, Lord, if Lordship allows me, I will take your Lordship to that also. While deciding, Honorable Court has said that even if the sanction is awaited or sanction has come, but the sanction is not proper, because the sanctioning authority has, whether they have properly given it or not, within time or not, those things are there. In other case, Lordship will find that first sanction is wrong, second sanction is wrong. Then court said, okay, you process it for another sanction. But in the meantime, what will happen? That is the question. Ultimately, they have a right to pay for regular bail before the court, since such it has been submitted, not for default bail. That is the answer.
Okay.
So, my lord, para 27 to 31, it is on the point of under 167 on default bail.
Okay.
On default bail. That my lord, I will not take your Lordship.
27 to 31. Okay, then.
31. My lord, my next point, Lordship, already for that 34, Lordship, I have already read. The provision has been quoted there. And my lord, paragraph, why that provision has been brought, para 38, Lordship has already noted. I have read, my lord. Kindly now come to, my lord, para 41. This has some relevance, my lord. Para 41, my lord.
Just a minute.
Lordship.
Para 41.
That will be
Section 22. Yes.
We find no merit, issue number 1.
Paragraph 40?
Para 43. Sorry.
43.
Final analysis. Issue number 1. We find no merit in the principal argument canvassed on behalf of the appellants that a charge sheet filed without sanction is an incomplete charge sheet, which could be termed is not in consonance with the subsection 5 of section 173 of CRPC. It was conceded by the learned counsel appearing for the appellant that the charge sheet was filed well within statutory time period of, that is 180 days. However, the court concerned could not have taken cognizance of such charge sheet in the absence of the order of sanction, not being a part of such charge sheet. Whether the sanction is required or not under a statute is a question that has to be considered at the time of taking cognizance of the offense and not during inquiry or investigation. There is a marked distinction in the stage of investigation and prosecution. The prosecution starts when the cognizance of the offense is taken. It is also to be kept in mind that cognizance is taken of the offense and not of the offender. It cannot be said that obtaining sanction from the competent authority or the authorities concerned is part of investigation. Sanction is required only to enable the court to take cognizance of the offense. The court may take cognizance of the offense after the sanction order was produced before the court, but the moment the final report is filed along with the documents that may be relied on by the prosecution, then the investigation will be deemed to have been completed. Taking cognizance is entirely different from completing the duty of the investigating agency, but taking cognizance of the offense is the power of the court. The court in a given case may not take cognizance of an offense for a particular period of time, even after filing of the final report. In such circumstances, the accused concerned cannot claim their indivisible right under section 167(2) of the CRPC for being released on default bail. What is contemplated under section 167(2) of the CRPC is that the magistrate or designated court, as the case may be, has no power to order detention of the accused beyond the period of 180 days or 90 days or 60 days, as the case may be. If the investigation is concluded within the prescribed period, no right accrues to the accused concerned to be released on bail under the proviso to section 167(2) of the CRPC. Next para. Once a final report has been filed with all documents on which the prosecution proposed to rely, the investigation shall be deemed to have been completed. After completing investigation and submitting a final report to the court, the investigating officer can send a final report along with the evidence collected and other materials to the sanctioning authority to enable the sanctioning authority to apply his mind to accord sanction. The according sanction is the duty of the sanctioning authority who is not connected with the investigation at all. In case the sanctioning authority takes some time to accord sanction, that does not vitiate the final report filed by the investigating agency before the court. Section 173 of the CRPC does not speak about the sanction order at all. Section 167 of the CRPC also speaks only about investigation and not about cognizance by the magistrate. Therefore, once a final report has been filed, that is the proof of completion of investigation, and a final report is filed within the period of 180 days or 90 days or 60 days from the initial date of remand of accused concerned, he cannot claim that a right has accrued to him to be released on bail for want of filing of sanction order.
Section 40, paragraph 47 is important for
Paragraph 47, next, Lord.
isn't it?
Yes, paragraph 47. Lordship has read, Lord.
My problem is that I read a little bit faster. So
I
I have completed 46, 47.
Lordship, kindly come to 49 also.
Yeah.
49 also. The maximum period of 180 days, which is being granted to the investigating agency to complete the investigation in the case wherein the prosecution is for the offense under UAPA, is not something in the form of a package that everything has to be completed, including obtaining sanction within the period of 180 days. As observed above, the investigating agency has nothing to do with the sanction. Sanction is altogether a different process. Sanction is accorded.
That is not just now I have expressed without
Yes.
reading this paragraph.
Yes, Lord.
They will get to have that period.
Yes.
Therefore, sanction will be post investigation. In the midst of investigation, they cannot seek a sanction because
Yes.
they will have to place all the materials they have collected. This can be a situation where they say that our investigation is complete within 90 days. We are happy. This is, you take and give us the opinion. That is a different issue. But they will get time up to 180 days to complete. This is statutory
Yes.
given.
In fact,
If they complete within 90 days, it's up to them and send it. That is a different issue.
so now the question is that when the sanction order is not came,
Now the
what will
question
happen?
is whether cognizance without sanction is a valid cognizance.
Malad, there is difficulty.
Huh?
But ultimately the sanction has to be there.
Sanction has to be
Sanction
there.
has to be
Okay, that is, there is no
Matlab-
parallel. I have also seen.
Matlab,
Suppose sanction goes,
Logic.
will interfere.
Logic.
Suppose that sanction, cognizance without sanction is bad. Therefore, it is liable to fall.
Matlab.
If cognizance falls, all subsequent action will fall. Because there are two different aspects. One is a cognizance. After cognizance, the stage of 227 or 228 will come, not at the stage of cognizance. So here is a case where after cognizance 227, charge has also been framed. Suppose now we hold for the time being that this cognizance is bad. This cognizance is bad for want of a mandatory prescription under UAPA. So therefore cognizance gone. Moment cognizance gone, charge is irrelevant.
Yes.
So charge is also gone. Then what? That
They have
is
to-
what I
they-
want an answer.
They have to come, they have to start from the stage of cognizance.
Okay.
The court has to come because
Now,
the
in
sanction
the
is applicable.
meantime, what is the status of this accused person?
But they continues even if suppose sanction is
Your argument is that yes,
sanction is
yes, now sanction is given, but if there is further delay in taking cognizance discharge, they can prefer an appeal because their right has been violated for delay or mistake on the part of prosecution. This is the case. This is what is your case?
But my
I will let him finish.
Matlab,
I could understand. His case is that, okay, even if we set aside the order, everything falls, search sheet is filed within 180 days. They are inside, behind bar. So they can be released only on a bail.
That is their case, Your Lord.
That is not otherwise. Because he is
everything
relying
will-
on this judgment only for that purpose.
Matlab, here
You will
Lord-
probably rely on Babu Thomas, Your
Hmm.
Lordship. Babu
Yes.
Thomas says the fresh sanction and then prosecution sanction, fresh prosecution sanction, fresh cognizance. That Babu
But
Thomas says.
ultimately, kindly, Matlab, Lordship will see, this is the situation, this is a situation where suppose cognizance is not there, charges has been filed,
is what I'm
the court is waiting for the sanction order. In the meantime, what will happen to them? That will happen here.
That
Matlab.
is what I am,
Lord-
what I have expressed. That is you are.
Yes.
Yes.
Yes, Matlab. Kindly, Matlab, come to 2015-14, Matlab.
2015.
2015-14 SCC 186.
Yes, paragraph.
24 and 27, my lord. Kindly come to para 24, my lord.
Paragraph 24.
24.
Hmm.
In the case at hand, I'm not taking to the detailed fact, my lord.
Okay.
In the case at hand, the special court not only entertained the contention urged on behalf of the accused about the invalidity of the order of sanction, but found that the authority issuing the said order was incompetent to grant sanction. The trial court held that the authority who had issued the sanction was not competent to do so, a fact which has not been disputed before the High Court or before us. The only error which the trial court, in our opinion, committed was that, having held that sanction to be invalid, it should have discharged the accused rather than recording an order of acquittal on the merit of the case, as observed by this court in Baijnath Prasad Tripathi. This is 1954 case, my lord. The absence of a sanction order implied that the court was not competent to take cognizance or try the accused. Resultantly, the trial by an incompetent court was bound to be invalid and non-est in law. Then, para 27, my lord, Babu Thomas case has been quoted in para 26, 27, my lord. The High Court has not, in our opinion, correctly appreciated the legal position regarding the need for sanction or the effect of its invalidity. It has simply glossed over the subject by holding that the question should have been raised at an earlier stage. The High Court did not, it appear, realized the issue was not being raised before it for the first time, but has been successfully urged before the trial court. But ultimately, court has said that from that stage only, it is open for them. Now, in Babu Thomas lordship, this is 2005 8 SCC.
Babu Thomas, it was sanction was invalid.
Sanction was invalid. Sanction was invalid, therefore said that fresh sanction you can obtain.
Suppose sanction is valid, but
Sanction-
cognization is some cognization is taken without sanction.
That Babu Thomas said that is wrong. That is wrong.
That is wrong.
Yes,
That
Babu
is wrong.
Thomas said.
So then what is the effect of that?
Then not cognizance go. Cognizance
Cognizance goal,
goes.
there should be a,
Sanction is
there should be a discharge. Now, the moment it is discharged, because SARS cannot be, it should be discharged for not on merit, but for want of sanction.
Sanction.
Now, what then next?
That is the situation where we in my respectful submission we have to visualize that charge sheet is submitted, sanction is awaited, there is no order. Ultimately sanction has come.
According to their, there must be, except bail, there cannot be any provision of.
No.
That is your case.
That is my case. Next
Now, Babu Thomas.
Babu Thomas, kindly come to para 8 on
2005, isn't it?
2005 8 SSC 130.
Paragraph
8 onwards,
8.
Or kindly come to para 12, 12, 13, 14 and 15.
Just a minute. Okay.
As already noticed, the sanction order is not a mere irregularity, error or omission. The first sanction order dated 2/1/1995 was issued by an authority that was not a competent authority to have issued such order under the rules. The second sanction order dated 9/7/97 was also issued by an authority which was not competent to issue the same under the relevant rules, apart from the fact that the same was issued retrospectively with effect from 19/4 to 94, which is bad. The cognizance was taken by the special court, special judge on 29/5/1995. Therefore, when the special judge took cognizance on 29/5/95, there was no sanction order under the law authorizing him to take cognizance. This is a fundamental error which invalidates the cognizance as without sanction. Then kindly para 14. Having regard to the gravity of the allegations leveled against the respondents, we permit the competent authority to issue a fresh sanction order by an authority competent under the rules and proceed afresh against the respondent from the stage of taking cognizance of the offense in accordance with the law.
Okay.
So as if sanction is not there, and in all these cases, logic will see, trial is already at the verge of finishing. In our case, the dates are very important. I have referred to the dates. The charge sheet, cognizance was taken.
I do not think Suresh Kumar will be required. This is a default bail only.
Suresh Kumar default.
It is not necessary for.
Logic.
What about Ashraf Khan, 2012?
I have also retired.
That is regarding.
On the same point.
Same point.
In fact, this clears the position. But in our case, dates are important. I have already given. On 13/9/2020.
Just now, let me record the date of this case.
Yes.
Bhotakar, you will also give the dates. Huh?
Lord, I have already
Given.
I
Okay.
I will give.
No, you have already given.
One minute. But from here on, I'll give on 13/9/2023.
On 13/9/2023.
The order was passed, taking cognizance.
Okay.
6/7/2023.
No,
6
13/9 is
39 is cognizance taken. That
13.
13/9.
Okay.
13.
2023.
2023. Cognizance taken. Charge sheet in this case was submitted on 6/7/23.
6/7/2023 charge sheet.
23. That's to do. 6/7 on On 7/7/2023, the
Just a minute.
logic.
7/7/2023, IO sends this to
SP send it to the commissioner and secretary through IGP Western. He actually given it to IGP Western Range,
through IGP.
Western Range, Bongaigaon.
Okay.
He
Then
placed it before the IGP.
now
Then
IGP.
Then IGP on 31/7/2023 send it to the Commissioner of Home and Political, Commissioner and Secretary of Home and Political at this group.
Then
Well, before the independent committee, it was placed on 11/10/2023. The joint secretary,
just a minute.
joint secretary placed it. Before
When?
11/10/23.
Committee, permanent committee, na?
This is independent review committee.
Independent review.
Independent review committee under section 45 of the UAP Act.
Okay, then 11/10.
On 11/10 itself, the committee has passed an order. It said that on 12/10 for report they have fixed. 12/10.
They file for gives the recommendation.
They give the report. Yes, my lord. The report they have given.
Report recommending sanction.
Recommending sanction. Then on 13/10, government has passed the order of recommendation.
21/10, is not it?
Hello?
The 11/10, 12/10,
Yes, my lord.
12/10 committee says recommendation, then
13/10.
on the next date itself.
Next date itself, government has passed the order, the sanction order.
Okay.
And now
Just take note of this, just I am repeating.
Logic.
On 6/7/2023, search sheet was filed. Okay.
Logic.
On 7/7/2023, it was sent, SP sent it to the IGP, Western Range.
Western Range.
Okay. On 31/7, Commissioner and Secretary, IGP sends it to the Commissioner and Secretary.
Yes.
Okay.
Logic.
Okay. On 13/9, cognizance was taken. Then 11/10, it was sent to the home by the home.
Joint
It was
Secretary.
sent to the committee.
Independent review committee.
Independent committee.
Independent.
On 11/10 itself, committee says fix this matter tomorrow for report. 12/10.
Yes.
On 12/10, report was submitted. On 13/10/2023,
No.
sanction was granted.
Yes.
That facts are correct?
Yes.
Okay.
These are the correct things. Therefore, but considering the position, my submission is that, since the sanction order has come now, and from that stage, suppose the court is waiting for the, after submission of the charge sheet, court is waiting for the sanction. And sanction has come, from that stage it will go.
Okay, Borsapur. We'll finish it up. Is that it? Or
No, Your Lordship.
we'll finish it up?
Now, Your Lordship, there.
Because we don't have any matter. We'll not come back again. Yes.
Your Lordship. may
We'll have
kindly-
the lunch a little bit
No,
later.
sir, no issue. Your Lordship will kindly see, Your Lordship, the date of cognizance is not, date of search, date of framing of search is 13/9. Date
We-
of order taking cognizance has in fact not been annexed, Your Lordship.
What should be a date of cognizance?
That I will you have to inform you. In the petition also, it was not mentioned the date.
Now,
of the-
what should be that date?
Date
Are you
is
able-
Prior to Your Lordship framing of charge, Your Lordship.
Yeah, of course, but what is the date to record?
Lordship, I will provide that, Your Lordship.
You have it, huh?
Lordship.
Okay.
And then
13
Your Lordship,
So 39,
Is the-
you
is-
say it to be a framing of charges. Okay,
now Your Lordship will kindly
just a
see.
minute, let me correct it.
Issue of sanction is Your Lordship point which can be raised at any
Any
point of time. That has been a subtle position only. We have raised it in the at the time of framing of charge, Your Lordship. Now, Your Lordship, there are two issues I will address, Your Lordship. Will not take much time, Your Lordship. First is, Your Lordship, that
Just a minute. Let me separate Nath's argument and his judgments, okay? Then I'll come back to you. So Nath is basically, we are relying on the Babu Thomas, then Nanjappa, and then 2023.
Well, in 2023, but kindly just para 54 also.
Para 54, okay.
What will happen? What will happen in that case? Bail or just reading one sentence below. Once a para 54 in the middle portion, Lordship will
just a minute.
Lordship. In the 2023 case below. The last portion below. Has Lordship got para 54. However, once the charge sheet was filed within the stipulated period, the right of the accused to statutory default bail come to an end, and accused would have entitled to pay for regular bail on merits. It was so and so, and last portion, acknowledging the fact that an accused has to remain in custody to some court. This court concluded that on filing of the charge sheet within stipulated period, the accused continues to remain in custody of the magistrate till such time as cognizance is taken by the court trying the offence, when the said court assumes custody of the accused for purposes of remand during the trial, so and so, so and so. So this takes care of the situation.
Okay. Just a minute, just a minute. Musumi. Need to clip kora. Then you keep it rakhi separately. Yes, Botakur.
Lordship will kindly come to pay the rule, your Lordship. Rule 3 and 4. Your Lordship has gone into it, your Lordship. There's no requirement to read again and again.
Yes.
But the point that has fallen from your Lordship's mouth is that whether what will happen if a particular officer is sitting over the file and not sending it to the what will be the result of such delay, your Lordship. Now, your Lordship, my humble submission, your Lordship, will be this, your Lordship. This rule 3 and 4, your Lordship will find, has certain objects for which this has been brought in. And it is related to your Lordship Article 21 of the Constitution of India. So that a person who is in custody need not suffer. Because there may be a situation where the government may at some point of time may think that, I am not talking about this case alone, your Lordship, but generally, your Lordship, there may be a situation of your Lordship that the government may think that this is not, or the review committee may feel that this is not a case where the sanction should be granted for prosecution. This is a frivolous case. So in a situation of that nature, your Lordship, this has, since it has linked to the it has its link with the Article 20 personal liberty of an accused, your Lordship, your Lordship will have to read into some reasonable time period to this process, your Lordship, by which, your Lordship, the material from the investigating officer reaches the independent reviewing authority. Otherwise, your Lordship, this 7 days and 7 days of period, it would have no meaning at all, your Lordship. Virtually, the speed at which they are required to work, your Lordship, this itself shows that this purpose behind this is to protect the interest of an accused, your Lordship. Now, if that is not there, your Lordship, that in my humble submission will vitiate the sanction order itself, your Lordship. That sanction order which has been passed after waiting for around 2 or 3 months, your Lordship, and your Lordship will kindly note what has happened in this case, your Lordship. Till framing of charge, there is no sanction order. When we came before this honorable court, your Lordship, and that is why the speed, your Lordship will kindly see, we have filed the petition here on the ground, and your Lordship will find IGP send it to the Commissioner and Secretary on 31/7/2023. Then, your Lordship, Commissioner and Secretary is sitting over the matter. Suddenly, when this question came up before this honorable court in this present
now tell us, when have you filed this petition before this?
Your Lordship, just before 10th, your lordship, you have filed it.
410.
410, your lordship.
If it says 4/9,
But its filing is on
410.
410.
410, this was.
No, 49 cannot be because it was after 30.
that
It
is
should be
wrong.
fine.
That
That's
is
a
wrong.
wrongly
Page,
typed.
page 15.
But it was filed on
410, your lordship.
410.
Now, your lordship, after.
No, it was corrected in this
Right.
affidavit.
Okay.
October. It was corrected.
Now, your lordship,
Just a minute. Yes.
and when we raised this issue, your lordship, they got up from slumber, and then your lordship immediately processed it, your lordship. Therefore, your lordship, on 11/10, this is the recommendation of the independent authority. Then on 12/10, your lordship, the sanction order was passed by the. Now, this itself, the delay on the part of the commissioner and secretary itself, your lordship, vitiates the sanction order, in my humble submission. That is one part, your lordship. Now, and your lordship, I will rely on one judgment, your lordship, that
Just a minute.
on interpretation, your lordship.
Mm.
How are we going to interpret this provision and why? This is your lordship 1987 1 SCC.
Just a minute.
Now, your lordship will kindly see
Paragraph.
para 33, your lordship. It will have to be interpreted in a manner, your lordship, these rules, your lordship, rules 3 and 4, your lordship, which subserves the objective of the provision, your lordship. Para 33. May I read, your lordship?
Just a minute. Yes.
Interpretation must depend on the text and context. They are the basis of interpretation. One may well say, if the text is texture, context is what it gives the color. Neither can be ignored. Both are important. The interpretation is best, which makes the textual interpretation match with the contextual. A statute is best interpreted when we know why it was enacted. With this knowledge, the statute must be read first as a whole and then section by section, clause by clause, phrase by phrase, and word by word. If a statute is looked at in the context of its enactment with the glasses of a statute maker, provided by such context, its scheme and sections, clauses, phrase, and words may take color and appear different than when the statute is looked at without the glasses provided by the context. With these glasses, we must look at the act as a whole and discover which section is clauses, each phrase, and each word is meant for design to say to fit into the scheme of the entire act. The context is important, your lordship. Now, context here is, your lordship, that there is the time limit, your lordship, provided by the statute, your lordship, so as to, your lordship, ensure that the accused does not be prejudiced, your lordship. Since
Because according to you, there is also a probability of not granting the sanction.
yes, your lordship. Yeah. And
Because the sending it to an independent authority itself says that
there is possibility. And your lordship will kindly note, your lordship, in the while interpreting these rules, your lordship, we cannot look at it only from the point of view of this particular case. It's a general provision, your lordship, applicable to all. There may be cases. Therefore, your lordship, it is necessary that the reasonableness of time, your lordship, sending the materials by the end from the end of the investigating officer to the independent reviewing authority, will have to read into these rules, your lordship. This is, and if it is not there, if your lordship help, the delay on the part of the investigating agency or the authorities to send it today is not reasonable, then it vitiates the sanctioning order itself, your lordship. That's my first submission, your lordship. And
Okay.
secondly, your lordship, which I am Babu Thomas, your lordship, so far as the your lordship may kindly come to the 227 for a moment, your lordship.
CRPC.
CRPC.
Yes.
225, trial before a court of session, your lordship.
225, yes.
In every trial before a court of session, the prosecution shall be conducted by the public prosecutor. Then 226, opening of case by the prosecution. Then 227. If upon consideration of the record of the case and the documents submitted therewith, and after hearing the submissions of the accused and prosecution in this behalf, the judge considers that there is no sufficient ground for proceeding against the accused, he shall be discharged, he shall discharge the accused and record his reason for doing so, your lordship. Now, your lordship, in our case, your lordship, he framed charge. We challenge that, your lordship. Now, ultimately, if your lordship, this order goes, your lordship, for any account, your lordship, then only option, your lordship, available in my humble submission for this honorable court is to discharge the accused person, your lordship. Now, your lordship, if they are discharged, discharge means, your lordship, there is no ground to proceed against this as on that particular date, your lordship, since sanction order was not there. Now, the moment discharge, how can this accused be kept in custody, your lordship? Discharge mean, your lordship, that is why, your lordship, no ground to proceed, your lordship.
Okay.
And therefore, your lordship, here, while using the words, your lordship, upon consideration the record of the case and the document submitted, your lordship. That document, this part is very
That document according to you the sanction.
Use the sanction.
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 Therefore, he cannot have a jurisdiction to
Lordship.
go for even exercising his power under 227.
Lordship. Now,
This is-
therefore, your lordship, he will have to be discharged. Now, the consequence, your lordship, if discharged, your lordship, then your lordship, the authority can always, your lordship, the investigating agency, ultimately this sanction order, once they will have to file a supplementary charge sheet, your lordship. They cannot bring it to the record without filing a supplementary charge sheet, your lordship. They will have to file a supplementary charge sheet with the, and once this supplementary charge sheet will be filed, someone will be issued, your lordship, against this accused persons, your lordship. They will have to appear, file for regular bail, and if honorable court, your lordship, feels that this is not case of granting bail, they will be sent to the jail, and then, your lordship, the question of the merit will come at later stage, that stage, your lordship. This is my humble submission. That will be, your lordship, that will be as per the, your lordship, procedure laid down in CRPC, your lordship, read with, your lordship, Unlawful Activities Prevention Act 1967. Ultimately, they will have to face trial. There is no doubt about that. Even if this sanction is held to be bad, there will be the investigating agency will always be entitled to come up with that is a settled position of law with a valid sanction order. And therefore, your lordship has seen in every order, your lordship, the word valid sanction has been, sanction is qualified by the word valid by the Honorable Apex Court, your lordship.
That's all.
This is my humble submission.
I have 2 line reply, my lord. Just to add, number one, my lord, this sanction order is before your lordship. It is not under challenge.
Not under challenge.
It is not under challenge. And secondly, my lordship, this charge sheet file under 167 has sought to be, my lord, qualified by a sanction order. But in fact, the 2023 decision, it clarifies, if lordship, 47 and 54, those are there. And further paragraphs are there that 167 charge sheet file under 167 is a completely different thing.
Court
Matlab
says it is a
sanction-
part of investigation. It is up to the investigating authority to investigate and complete the investigation, and it is part of the sanctioning authority to give. There is no business of the investigating authority for the sanction. This is
And my lord, it is not a case that this charge sheet has to be approved by the sanction authority, by the sanction order. Sanction order is a 173(5) court has said it is a sanction order is a protection so that misuse should not be there. But if sanction is not given, lordship has posed the question that if sanction is not given, then my lord, there is scope for further supplementary charge sheet. Reinvestigation scope is still there. It is still there. It is not a case that everything ends if sanction is not given.
Further investigation, not re-investigation.
Further investigation can be there. So in that case, in that case also, my lord, the benefit of discharge, what the petitioner has prayed, that will not come. Because 47 and 54 paragraph has taken care of that.
We are fixing it, some within these days, we'll try to.
One more submission, Your Lordship. I have not argued on the point of merit, Your Lordship. But in fact, Your Lordship, if you, I have annexed everything and record is also there. If Your Lordship go through the statements of the witnesses, Your Lordship will find that the section 15 of UAPA will not remotely come to this case, Your Lordship.
You say that there is no scope of suspicion.
Absolutely, Your Lordship.
Because discharge, this time of discharge, only consideration will be that there is no even suspicion.
Grave suspicion.
But in fact, this is not a case of discharge, my lord. Discharge is not challenged.
No, that is, we are not going on.
Paragraph 10. Paragraph 10 is the case.
No, we will not go, then we will have to hear you, no?
Yes.
That we are not going.
Then
We are only dealing with this point.
Paragraph 10.
Then you argue again.
Yes.
Before that, sorry, that I would.
Para 10 of the petition is the petition is the
Yes, that part will not go.
Yes, that is why my lord, I have indicated that.
Or at some length, fix it for further hearing. We'll dictate it because we're not keeping it CAB. If not possible, on the next date, we'll keep it as, then we'll make it CAB for further hearing on Friday. 7th.
My lord.
Deeply obliged.
On that day, lordship will dictate the order.
I will try to dictate. If not possible for other time, then we'll make CAB on that day so that Saturday, Sunday can be used.
My lord, lordship.